We'll come back to that in a minute.
We'll come back to
that. But I think just to explain as well to people is that, you know, as part of this has been exhausted. It's not been just about the murder inquiry. You know, and this is the problem with this case is disclosure.
Yes.
Because there is a mass of other material that was available at the time that has never been disclosed but sits there in the background. And we know that as a result of an email and a letter that was sent to Essex Police, I think it was probably a mistake, Kevin Macey, who's head of cold case reviews, responded and said there, I think he said it was 122 123 crates of undisclosed material in this case.
Yeah, there was 124 boxes of case papers, and what we are saying is it has all that been disclosed.
And it hasn't. We know it hasn't.
And is that just to do with
some of it has been disclosed because it was proved the case.
So this is where we think some of this material is. So as part of our investigation, this all sits in there in our investigation. So you got the murder of Nick Whiting, who was kidnapped on the 7th of June 1990 and murdered. You got the death of Kevin Whitaker, who died on the 17th of November 1994, and again that's a complete balls up. The death of Leah Betts, which is absolutely intrinsically involved in this case, who died on the 16th of November 95, which is as important as the number 13 of 95. That's the incident number for that year for Essex Police. The Rettendon murder inquiry, which is the investigation of the murders of Tucker, Tate and Rolfe on the 6th of December. Incident 11, which is before the Leah Betts on the, which is incident 13, which is a bit strange.
What could have happened there is that the Leah Betts case didn't become a crime case until after. So the date, So there is not a huge point, but it is a point.
Stillwell was convicted at trial on the 1st of September 1997 to January 98. You then got the murder of John Marshall, which is an unresolved investigation of the death of John Marshall on or before the 22nd of May 1996. And Albert, you had some involvement in that. And you've also spoken to the SIO on that case. Operation Cluster was the covert investigation of Tucker, Tate and Rolfe by Essex Police Drug Squad. Really important because Essex Police deny categorically that there was a surveillance operation on Tucker, Tate and Rolfe. We know that's untrue.
No, it's untrue,
Operation Toy Box was a covert investigation of Still and Wones by Customs and Excise that commenced in April 1996. That's incident 5 of 96. Operation Goshawk was a joint operation between Customs, South East Regional Crime Squad and Essex Police regarding the importation of cannabis that they were arrested for on the 13th of May 1996. That's incident 6 of 96. And I was directly involved in that, and as I arrested Darren Nichols for that importation.
And again, just to interject, completely the wrong field. Complete for reasons you've gone into.
Absolutely. Operation Viper, which was the security of the protected witness Darren Nichols, and we have actually spoken to the people who protected Darren Nichols, arm protection, and very interesting. In fact, one of them was interviewed for the Sky documentary. It was never shown, but that was mind-blowing. They basically, I think his own words were they bought his evidence. He was treated like a king. Operation Apache, really important again, the corruption inquiry into Wolfgang Bird and Dear Stimpson and Darren Nichols, which was incident 15 of 95. The CPS stated that date it commenced was April 1996, but that is clearly not correct based on the incident number alone. And the big question there is, we're not sure, I don't think it's right, there's no evidence to suggest it, but we are concerned that Darren Nichols was actually an informant prior to the murders. We don't know. Operation Grenadier, really important, never disclosed. The corruption inquiry into the activities of Detective Inspector George Florence, who was acting Detective Chief Inspector, the Deputy SIO for the Rettendon murders. This was only disclosed by the CPS during the trial of Still and Wones in 1997. And the importance of that is, number one, the Deputy SIO, he was probably the most important person in the case, if you think about it, because you had the Superintendent Dibley, who was retiring, probably didn't have much interest in it because he was about to retire, and so the person who was probably running it at the time was George Florence. And if he was under investigation for corruption, that should have been disclosed. Our understanding of the case is he was allowed to retire when he was served with the corruption papers. But that whole case is, again, Essex Police refused to disclose any details. Another massive case that's really important, Operation Sentry, which was the fraud undercover operation by Essex Police and the RUC, where they tried to put an undercover operative into Michael Steele and to Sarah, Pat Tate's girlfriend, mother of his child. We'll come into that in more detail later, but again, not disclosed. And importantly, brings in another officer, I won't name, but brings in another officer who is absolutely intrinsic to this whole investigation and is effectively the reason why, your words, the whole thing become blinkered, because of his involvement with two informants, who again we won't name, but two people who literally on the days after the murder gave information to Essex Police and to this particular officer, and as a result of that there was a meeting held at Essex Police headquarters with the Deputy Chief Constable, and that set the tone. As far as they were concerned, from that point on, Mickey the pilot, Michael Steele, was the primary suspect for this murder, and as your words, from that point on the whole thing became blinkered. And then again, massively important, been disclosed, but was very it was kept very narrow, which was the Section 19 inquiry by Hertfordshire Police between 2002 and 2004, and that was a set up, and we've spoken to the people in charge of Operation Obtain, and that was effectively set up as a result of the application to Court of Appeal by Steele and Womes, and it was looking at whether or not Darren Nichols was paid or involved with the media prior to giving evidence at trial. What happened is that there came to be evidence, and it is evidence because they made witness statements, from other serving prisoners who were serving alongside Darren Nichols in the secure unit, protected witness unit, and 5 of those people serving with Darren Nichols made witness statements, 2 very, very significant ones, cousins who, and we've spoken to him, who state Darren Nichols told them that he was going to lie at trial, this is prior to the trial, was going to lie at trial, and was being coached, and his evidence was being manipulated. Massive, massive, massive issue. So they're a list of the other investigations that we've looked at as part of that. And we can go into more detail about those.
Just to put a bit more meat on the bones, those individuals who were in protected programmes would all have been accepted as witnesses of truth.
Absolutely.
And that's the key here. Yeah. These are not just prisoners just for the benefit of the wider audience. Yeah. These are witnesses of truth.
Yeah.
And 5 of them have said that's what he told us.
Yeah.
But the key one there is
cousins.
His cousins. His evidence is just that. It should have been listened to by the Court of Appeal.
Absolutely. Yeah. And I think, I know we're sort of going into a bit more of the weeds, but the reality of the cousins' evidence is it wasn't Cousins just made a witness statement afterwards. Cousins was keeping a diary. Yeah. He had a written diary every single day, in which he was writing what Darren Nichols was telling him. He was writing about the events of his time in prison, but he was writing down what Darren Nichols was telling him at the time. He then transferred that entire written diary onto a computer when he got a computer when he was in prison, and so it's all time-stamped effectively. It's all absolutely, spot on. The evidence is correct. It's recorded at that time. And he has written at the time almost a verbatim note of Darren Nichols admitting that he was going to tell lies and was being coached by Essex Police officers.
And as we know, Cousins was a highly erudite man. That's the other thing. This is not a fool.
No, he's a very, very intelligent man. And again, as you said, Albert, went on to give evidence against one of the most significant senior criminal groups in the UK, and his evidence was accepted as evidence of truth. Why would you then believe him when he says this?
But our confusion is what sits within the CCRC as to why they did not do anything constructive about it.
Yeah.
The only thing to do is to refer it. but we don't know what the outcome of that has been. Don't see anything.
So this is the important bit of this, and this is your point that you make continuously, Albert, is around disclosure.
Yeah.
You know, and the rules around this are as follows. Essex Police had and still have a duty to disclose relevant material. This duty to disclose is a continuous one. Therefore, if at any time before the accused has been acquitted or convicted of the alleged offence, the prosecutor feels there is material that might undermine their case or assist that of the defendant, that material must be disclosed. It's Criminal Procedure and Investigations Act 1996, CPIA 96, as amended by the Criminal Justice Act 2003. Post-conviction disclosure, the interest of justice will mean that where material comes to light after the conclusion of the proceedings that might cast doubt on the safety of the conviction, there is a duty to consider disclosure. Any such material should be escalated in accordance with local arrangements. The principle was considered and the importance of finality in criminal proceedings was reaffirmed. So the reality of this is those 124 crates contain material that we believe, and most other people, you know, in policing in this day and age would believe is relevant and is disclosable. And that's the point, is that there's been mass scale, industrial scale, mass disclosure in this case.
But that only appertains to the Rettendon investigation, those 124 crates.
We don't know.
We don't know. So it actually could be many times more when you take into account these individual operations. And the problem I had with it, and you, I know, both had, was that if that volume of material had been disclosed, in all honesty, it would so undermine the prosecution case that it would make the conviction, irrespective of evidence or anything else, completely unsafe. Yeah. And that's where it sits with us, really.
Yeah. So the CCRC